All right, we're ready. Welcome to the ethics meeting. Before we get started, I want to remind the members of the committee that you are advised of your duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest. If anyone has one, you're free to say it now or as it comes up. So we're going to start with the special items.
Yes.
And Brian, are you?
I get to fill in for Ann today with the audit report. I know it's super fun. So you should have in the addendum materials, the report from Ann for the past quarter's audits. They were conducted in judicial districts 15 and 33. And these districts both have been previously audited. 15 was previously audited in 2018, 33 was audited in 2017. So in District 15, 21 audits were conducted, 14 audits were conducted in District 33. The three most common rule violations Ann found were all tied at 31%. 31% of those audited failed to review bank statements and cancel checks each month, escheat unidentified or abandoned funds, or maintain images of clear checks or maintain them in the required format. So it's pretty much the same story that we've heard each quarter. The next quarter's audits will be in Judicial District 24H, composed of High Point, and here in Buncombe County. That was not intentional that we were here in Buncombe County and selected. It really is a random process, but it just happens to be what it is. So that's where the random audits will occur next quarter.
Thank you. And I don't know how many of you went to the Lunch and Learn, but Ann did an excellent presentation. If you've never been audited, and I have, by Bruno, it's a fun experience. But if you haven't, she did an excellent presentation sort of talking about how that goes through. So next we're going to hear from Suzanne about the phone calls.
The inquiries we got last quarter, we answered 1,028 ethics inquiries. And as far as the topics, the top 4 for this quarter were the same as last quarter, and that is conflicts, confidentiality, trust account, and advertising.
Thank you. So next we're going to have Ryan talk about any presentations during the last quarter.
Right, and we had a less than normally active quarter, although we still had 3 total staff presentations for CLEs. I presented 2 and Suzanne presented 1. So we want to stress to everybody that yes, we are available to do CLEs in your districts, to your different organizations that you're all affiliated with. To provide an ethics hour, and I would say an entertaining and very instructive ethics hour as well, at least as much as the subject will allow us.
Right, we're going to start with the rule amendments and go to consideration of amendment to Rule 1.8E, and I will let Nicole give us an overview.
Thank you. So this is the proposed rule amendment that we've all been studying for a while that adds a humanitarian exception to the rule 1.8E. And the humanitarian exception will allow lawyers to make modest gifts of living expenses to clients who are involved in pending or contemplated litigation. It was published for comment after the April meeting, and I'm happy to say no comments were received. So that means you guys did really good work. And so it is our recommendation that the proposed rule amendment be sent to the full council for approval and then onto the Supreme Court for adoption.
Excellent. The chair, head of that committee, Judge Kirsten Mitchell, do you want to fill us in on anything else?
No, I just want to say that this is one of those no news is good news because we didn't receive any comments. I do think that our committee did a really good job. Staff did a really good job drafting that. But I would love for there to be a time when we actually get someone to send some comments saying, you all did great. Please hurry up and send this on. So that's all I have to do.
We keep waiting on it.
Right.
Yeah, does anybody else know Jack have a comment?
Well, there was an answer to that, and I can tell to you that I got a lot of comments. I got a lot of comments not only within our firm, Legal Aid, but also from a lot of our sister organizations. And I will tell you, they are very happy. And I had people telling me genuinely how much this will make a difference in the lives of the clients we serve. So people are very happy. They didn't want to comment maybe publicly, but I will tell you, I've heard a lot. I don't know if Ashley has, but it has definitely been something that most people in our profession take very, very seriously and are very excited about.
Thank you.
Any other of the sub members have any comment, or anyone from the entire committee? Otherwise, we have a motion.
We do. I move that we send it to council for adoption. Second. Thank you.
All right, we've got a first and a second to send the rule amendment to the council for adoption. Any further comment or questions? Seeing none, all in favor, say aye.
Aye.
All opposed? Motion passes. Thank you all for that. All right, next we're going to go to some pending inquiries and start with Brian talking about I would say double billing, but last time I was shamed. Overlapping billing considerations.
Yes, the overlapping legal services. So, I'm gonna do something that I don't normally do, and I want to actually go through the opinion because this thing has gone through, a number of different iterations. And I want to make sure that we're all aware. I'm just gonna briefly kind of go through the full outline of this thing, so you all, we're all on the same page. But this, you see in the report, you know, the subcommittee has met a number of times. We met, I believe, twice this past quarter, and we finally arrived at a draft that I know Davis can give some comments on as far as the subcommittee's reaction. But where we're at right now is this opinion that's in your materials that basically tries to clarify and tries to really address all the different considerations and concerns that we heard during publication and after from this full committee, from other members of the council and other members of the profession. So we first start off with just this question of, can lawyers provide essentially overlapping services? You know, that was one of the big questions that I think there was maybe some misunderstanding or maybe just miscommunication on the first opinion's part to this notion of, can a lawyer provide services to multiple clients at the same time? And the answer is yes, as long as providing those services, those overlapping services, doesn't detrimentally impact the services that you're providing for the clients. That's not an issue of providing services to multiple clients at the same time. But then there's that, we go to the next question of, can, you know, if you can provide overlapping services, can a lawyer bill each client a particular portion of the total time that the lawyer spent, i.e. you spent an hour for 4 different clients doing basically the same thing, providing the same service. So can I just bill everybody 1/4 of an hour? Yes, that's absolutely permissible. But then we get into the question of, okay, so now a lawyer providing overlapping services, they're at calendar call for 4 different clients. They attend, or they have 4 different clients on that particular docket. They spend 1 hour there. Can you bill 1 hour for each client for a total of 4 hours over that 1 actual hour? The answer being no. The opinion goes on to try to kind of flush out, and this is where our opinion, I think, takes a different approach than the other opinions that are out there in the different jurisdictions. We try to flush out, okay, well, if that's not permissible, what is, in an attempt to be helpful to the profession. So the next inquiry, just again, kind of that allocated question. Can I bill each of those clients 1/4 of an hour under those specific circumstances? Yes, you can. We already talked about that in the prior opinion. Can you charge a flat fee for each client? You've appeared at calendar call for 4 different clients. Instead of billing hourly, can I just charge a flat fee for every court appearance I make? Yes, you can do that. Then we get into the scenario that I think was more or generate a lot more discussion. That stuff kind of seemed clear, but the travel issue. I'm traveling for one client, but I'm doing work for another client at the same time. So how do we tackle that? The first question being, I'm traveling for the client. It's the same thing where I'm flying to Seattle for a deposition. I'm charging them my full travel rate, $150 an hour, but then during the flight, I'm working for another client and I'm charging them $300 an hour. So basically, I'm charging a total of $450 an hour while I'm doing the same doing services for 2 different clients at the same time. The answer to that is that permissible was no, and that was based upon the notion of, you know, you cannot justify basically charging 2 hours of work over 1 actual hour Not to mention the considerations of, the travel charge usually being justified in and of itself, at least the hourly travel charge being justified in and of itself, because it's something that's taking you away from your desk, but here you are actually doing work. It becomes a more kind of tumultuous issue. But the opinion, again, doesn't just stop there. We try to go on. Well, what exactly is acceptable? And so the next inquiry is basically looking at that travel scenario. Can I prorate my charges? I'll do 50% for this client, that's the travel bill, and 50% for the legal services. Yes, that is permissible. Next inquiry, asking, well, can we do a set fee, a flat fee that's not based on an hourly rate? Maybe it's a per diem, maybe it's a flat fee for travel services. The opinion says, yes, you can do that as well. I think the opinion gets down to a part of course, yes, we talk about the unit billing and try to say, for one, yes, that's permissible, and distinguish exactly why unit billing is a different sort of thing. And that's an inquiry in opinion number 10. But really, I feel like it all culminates in inquiry in opinion number 11. Yes, there are 11 different inquiries. It's not, I don't know if it's a record, but there's,
Check that.
we'll need
Could be a
to
record.
look into that. But inquiry in opinion number 11, basically the inquiry asks, are there additional billing structures that aren't covered by this opinion that would be permissible? And the answer is yes. The opinion really tries to kind of say that, the principle that we're looking at here is that billing needs to be transparent, it needs to be accurate, it needs to be honest, and it needs to be not clearly excessive. And so the opinion kind of recognizes that there may be other billing structures that are appropriate based upon the client's needs, the understanding of the client. And as long as that is communicated to the client and it's not violating rules in other ways, then those billing structures should be explored and can be implemented. So again, it's a long opinion. We tried to really flush out a lot of the different details. The subcommittee worked very diligently on this, and I'll give a special shout out to Lamar for offering a new structure for the opinion, which was really helpful in trying to kind of break down how we want to proceed through this analysis. So that opinion is before you, but I'll look to Davis for any sort of report from the subcommittee.
Thank you, Brian. I appreciate Brian's work on this. He's worked very hard, many different drafts of this opinion. But again, this started back in April of last year. We thought it was a no-brainer, and we ultimately arrived at the same conclusion, but that conclusion didn't provide any guidance or a lot of guidance to what was acceptable. So, we really, as a top priority, wanted to be able to provide guidance, but not micromanage how people bill. And along those lines, the two general rules that Brian touched on were, we want everything to be agreed upon by the clients. As long as the clients are aware of your billing structure, that, that's important, required. And second, that is not excessive and not dishonest. And so the first, I guess inquiry 3 really is an honesty issue. It's just dishonest. It's illegal, so now it's, with this opinion, it's unethical, and it's important. The one that caused more conversation was the traveling scenario. So I think, we've really worked hard to provide guidance. We have a very diverse group on our subcommittee of different practice areas. And Jack, was an integral part of it, does a lot of travel, does a lot of hourly work and so forth. So, we all had some issues with the travel part, but we came around to this opinion because it does provide ways to compensate yourself for doing both services at the same time, which is something that's important in the era of technology that we have, where you can work and travel at the same time. So I like the opinion. The second meeting this quarter was very short. We looked at it for 10 or 15 minutes. Everybody agreed on it, and so we're here to discuss it with the group, and we've heard everybody's feedback and tried to incorporate that here, and then ultimately we're going to have a motion on this.
Thank you, Davis. You've done an excellent job. That whole discussion that we have gone through, we have gone back and forth A to Z several times. But Davis, Dorothy, Lamar, Jack, and Bill, we have chased some rabbits all through this rule. So opening it up to anybody else who on the subcommittee or not on the subcommittee who has questions. Yes, Craig.
kudos to your group. I think this is a much better work product. It teases out everything in a great way. So thank you for your hard work on that front. I do have a question about inquiry 10 and opinion 10. I have a recollection that there's some reported decision in North Carolina from 25, 30 years ago where an attorney got excoriated.
Craig, can you just speak up or?
I'm sorry.
Yeah.
Excoriated for unit billing in a way where you could bill more than 24 hours in a day.
Yeah.
And taken to an extreme, that's what could happen here. Any thoughts, comments about that issue? Because I do think we need to be concerned about optics. My spider sense is I'd rather somebody else kind of take the lead on that, some other jurisdiction rather than us. But anyway, I'd be interested in hearing what you all thought about that.
So we did touch on that. So ultimately, and I think opinion 10 and 11 kind of touch on it. The hourly billing was the real problem here. Now, is this going to allow people to start doing half-hour increments and bill that way? And you know, it could, but I think ultimately the opinion as written would say, one, you know, did your client agree to whatever the unit billing structure is? And so if it's 6-minute increments and you're sending a 3-minute email and so forth, you know, is that something your client agrees to and they knew you were going to do it? Yes. Second, is it, you know, honest? Is it not excessive? And so I think that ultimately this, you know, if somebody would come in, you know, charging 45-minute increments and, you know, billing, you know, a 3-minute email, 45 minutes, this, you know, the grievance committee probably would have a problem with that. And I think this opinion has to.
And I'll add on that, that's one of the things that we saw as a distinction with the unit billing, that when you're unit billing, you're not exactly providing overlapping services. You're providing separate and distinct services. They might be sequential. You know, you're sending an email, it takes you 10 minutes, you bill in 15-minute increments. But then you send another email, that takes you 10 minutes, you bill in 15-minute increments. So understand that essentially where the opinion would say it's okay to bill those two units, which comprise 30 minutes for 20 minutes of actual work, but they are separate, they're not overlapping. The other thing was that the notion of unit billing is an attempt to address the clearly excessive framework bill, and that's the very last sentence of the opinion. That notably, while hourly billing is a form of unit billing, it is that billing in 1 hour units would be clearly excessive. You know, saying I'm going to spend 3 minutes on this email and I get to bill an hour. That's where it becomes clearly excessive. But if you are billing in those 15-minute increments, those 6-minute increments, that's an attempt by the lawyer to not charge a clearly excessive amount, but while also trying to manage their time. So I think that's where we tried to, you know, understand, and I understand exactly what you're saying, Craig. That's where we didn't want to write an opinion that would micromanage these different really accepted billing structures. And really, as long as the client is aware of it, the unit billing is going to be separate and distinct from other services, but also not clearly excessive. And when you have client consent, then the opinion finds that it's permissible.
Question, Craig?
Yeah.
Anybody else?
Yeah, on that, picking up on that point, quick question, 2 questions of, I should say, clarification. So I love, Brian has done so much work on this. I love the opinion as it is. If we changed anything to it, would that mean we wouldn't be allowed to go forward with it today? I had one thing that I saw this time that I hadn't seen before in inquiry 6. And I thought of it because of Craig's question and Davis's answer. In opinion 6, we use the phrase, the claim otherwise would be inaccurate and impossible. And I was a little bit, I noticed that for the first time when I was viewing this stuff again. And I am a little bit apprehensive about using the term impossible because I don't want to give any fodder for folks to be able to say, okay, you bill in 15-minute increments. You answer an email for 6, 7, 8 minutes. Have a phone call for 6, 7, 8 minutes. You answer another email for 6 minutes. Now, over that period of time, you might have spent 21 minutes working, but you've just billed 45 minutes. And I can see someone trying to use this language of impossibility to attack our colleagues who use 15-minute increments. And as Davis pointed out, I spent over a decade of my life doing 15-minute increments. And I know a lot of really hardworking colleagues of ours use that. And so it is inaccurate the way it's being utilized in inquiry 6. But it's the use of the term impossibility, I'm afraid, expands beyond that. So that's my first quick question. The other one is on inquiry 8. We went round and round about how to do a flat fee or unit fee type billing for travel that is not, as you pointed out, hourly. But for point of clarification, for those of you interested in inquiry 8 here, that does not, if I'm reading this correctly, but Brian, you correct me if I'm wrong, that does not mean you cannot front load your retainer agreement with the specificity of saying travel expenses when we travel for you under 1 hour, 0. If I spend 2 to 4 hours traveling for you, it's just $500 flat fee. If I spend more than 6 hours, it's $1,000, regardless of whether or not I'm watching a movie or on a plane or I'm writing a brief. That's a moot point because it's a flat fee. My point of clarification is just because that gets very close to someone being able to say, that's such a lawyerly semantical way. That's totally an hourly type billing. You're just saying 4 hours instead of 1. So we put ourselves into a little bit of a hamstrung situation where we're saying the language is a set fee that is not based on hourly, but I can front load a retainer agreement that says traveling from 2 to 4 hours is $500. Now I'm going to say and define that as a flat fee. But as I was reading this, I'm wondering, could we be giving ammunition to someone to say you're unethical, sue you for malpractice because you did an hourly? But anyway, I'll shut up.
Yes, Warren.
We're getting a bit existential. Human beings. We live in a 24-hour day and a 7-day week, 365 days a year. And we measure a lot of things by time. I'll see you in 2 weeks. I don't to measure again at the point today is not that we're trying to get around the label of double billing. The point is that we're trying to be clear with our client, not clearly accessible to anyone. And we are having to measure a need there. It's like the 6 minutes. There's all those needs. We have to measure it by the minute. I don't see how. And I think the way reads also, maybe there's some philosophical lawyer out there that comes up with another way to measure things by miles. If I right, I don't know what other units of measurement. If I gained 10 pounds on my trip. I mean, there's just other ways that we can measure things that just makes sense.
No, I absolutely agree with that, and thank you for that. I'm just trying to think in a protective way of all of our colleagues who do have to live under these structures. That's all.
Yeah.
But I love the opinion as.
Kevin?
I really appreciate what the subcommittee has done to take what was a simple question, complicated. But I thought with this, when I was reading this yesterday in preparation, I think this is excellent. And I think, Jack, to your issue, where I've seen in my practice where lawyers get in trouble, at least with criminal problems with overbilling, going 40 hours in a 24-hour period, it's chronic. And so what this opinion does, I think, can sort of set out the guidelines for individual cases. Now, lawyers that chronically abuse it are going to chronically abuse it, and they're going to get in trouble. But the lawyers that have once a month, travel and have these billing structures, I see no problem with that. I do see a problem, the lawyer does decide that they want to exploit this situation. And it's easily recognizable once you start examining those records. But this opinion, you know, and congratulations to this subcommittee. This is a difficult thing that we made that started out simple, but we managed to kind of really sort of slice this in a way that gives guidance, you know, general guidance. And as David said, we don't want to micromanage this with the lawyers. And so if we start down that path that you're talking about, we're talking about micromanaging. And then micromanaging the micromanaging. So I'm in favor of this.
I want to quickly address what Jack had said about the inaccurate and impossible. I think the word impossible need not be in the opinion for substantive purposes, just to clear that up. Everybody is fine with removing that word. We can remove that word and the opinion can be presented to the committee without those two words. I agree with you. I see what you're saying. I would just say just the period, or excuse me, the sentence ends with inaccurate.
Yeah. But Davis, is that?
Yeah, that's fine.
Yeah.
The
That
only
was gonna
other
be
thing to
my
add is
comment.
that we did want to, you know, I want to say that another important rule that we have or kind of aspect is we want to give the lawyers the benefit of the doubt that they're going to do the right thing. So this allows, you know, those who want to do the right thing, just guidance, and the ones who aren't, you know, the bad apples, whatever, they're going to do what they want to do anyway. So hopefully now we can prevent that or deter it.
So we've made that, yes.
I love this opinion. I think it's so much better than what we get from other states with the clarity. And this is not a substantive comment. This is where everyone can roll their eyes at the teacher. And it probably comes from writing too many NPRE questions, but is there a reason that inquiry 9 is written as is the lawyer prohibited? And could we write, I see why we did 10 that way, but could we write 9 as may the lawyer and get a yes answer?
So we had that discussion.
I'm probably willing to
I will give you there was I had a long thought process. It was Tuesday and I wrote it that way.
It's fine.
I could have written it the other way too. But there was something, I will say, there was something that I think instinctually when writing it, I wrote it that way of the notion of, you know, can you charge expenses? I think we all know you can charge your expenses. You can charge your mileage. So just to clarify, is there any prohibition on charging my plane ticket, my mileage, you know, the gas, as long as the client consents? For whatever reason, I felt like it made more sense to me to just say, no, there's no prohibition.
Leave it. That's fine.
That was
Perfect.
my
Yeah.
gut.
Yeah.
Any further questions, concerns, comments? If not, Davis, do we have a motion that you want to present?
Yeah, so not 100% on the procedure, but I would move to, I believe, publish this opinion with the removal of the words "and" impossible.
Yep.
Perfect. We have a first and a second on publishing this opinion with a removal of the words "and" impossible in inquiry 6. Any further questions, comments, concerns? If not, all in favor?
Aye.
Any opposed?
There'll be a party after the.
Right. All right. We'll move next to lawyer mediator drafting terms of mediation mediation terms for pro se parties. And Suzanne, you give us an overview, please.
Yes, this is still a work in progress. We're working with the Dispute Resolution Commission. Tara Kozlowski, the executive director of the DRC, has been working with the subcommittee on this issue. And the DRC is asking for guidance for lawyer mediators who are working with pro se parties. One of the difficulties of working with pro se parties is avoiding ending up giving legal advice to the pro se parties. We have an ethics opinion that talks about what lawyer mediators can do at the conclusion of a mediation with pro se parties, as far as drafting settlement agreements. This particular inquiry is looking at what the lawyer mediator can do at prior to the mediation beginning, when they need to establish the terms of the mediation with the pro se parties. Generally, the terms a mediator will want the parties to agree on include confidentiality, the prohibition on recording the mediation, and the inadmissibility of evidence relating to the mediation. If the parties are represented, generally their lawyers will get together and draft an agreement addressing these issues. But when there's two pro se parties, it's inevitable that the mediator is going to have to be involved in setting forth the terms for the mediation. We initially drafted a proposed ethics opinion, which stated that it would be permissible for a lawyer mediator to represent both parties, very limited representation of both parties solely for the purpose of coming up with the terms for the mediation agreement. However, we subsequently learned that the DRC, they have different rules than ours. They have a rule that would have prohibited a lawyer from having any representation of the parties before the process would prohibit that mediator from participating in the mediation. So the proposed ethics opinion was not going to be a feasible conclusion. The inquiry was sent to a subcommittee, and what we have been looking at now is the feasibility of a standard form approved by the AOC and the DRC that lawyer mediators could use with pro se parties. Basically, it would be a form setting out the terms of the mediation that both parties would have to agree to they'd have to agree to be bound to prior to entering into the mediation. Tara was participating in the subcommittee meetings, and she thought this was a great idea. And she agreed to work on a standard form with her forms commission and also with the AOC commission. And then she agreed that she would come back with a draft form for the subcommittee to review. She did come back with the first draft form, and the subcommittee met and we discussed that form with Tara. The subcommittee had some edits for Tara, some suggestions. They felt that the first draft was too complicated and veered into some legal issues, which might lead to the lawyer mediator ending up giving some legal advice. The subcommittee members also felt that the form should include a specific disclaimer that the lawyer mediator was not giving legal advice. Tara agreed with all of these comments. She was very appreciative. She agreed to go back to the committee and work on a second draft of the form. We just received a second draft. It looks like it incorporates a lot of the things we said, but we still, we want to go over that. So the subcommittee will be meeting in the near future to look at the second draft and hopefully be able to come up with something that we feel comfortable lawyer mediators using to press it on.
Thank you. Gina?
All I would add to that is this is a huge access to justice issue. So we need to make this process as accessible to the public as we can do so. And really, our role is more in advising the Dispute Resolution Commission on what their product needs to look like, so it doesn't run afoul of any professional conduct implications. So it's kind of their baby, and we're just helping them get it through. And we did just get the revised draft last week, maybe, so we didn't have a chance to meet again about it before today, but we'll do that.
Any other sub members or other committee members have comment? If not, do you have a motion?
Motion to leave it as
Second?
Second.
Hearing a first and second, the motion is to return or leave this matter in subcommittee. All in favor, say aye. Any opposed? Thank you all. So next we will have Nicole give us some information on proposed 2023 FEO2.
So this is, you may all remember, this is the proposed opinion that involved medical malpractice litigation, where the case was argued up to the Court of Appeals. New law was created at the Court of Appeals. It went back down for a trial, and the parties decided to settle the matter for the damages. The defense lawyer is the one who prepared the settlement agreement, and she included a confidentiality clause that would prohibit not only the parties, but also plaintiff's counsel from disclosing any information about the case, including the underlying facts and the names of the parties. Plaintiff's counsel objected to that on the grounds that it restricted her ability and her right to practice. She wanted to be able to talk about the new case law and any publicly available information at CLEs and writing and publications, listservs, things like that. So the proposed opinion rules that a confidentiality clause in a private settlement agreement that restricts the lawyer's ability to use or disclose publicly available information violates that lawyer's right to practice under Rule 5.6. The opinion was published for comment after the January meeting. We received 2 comments. One comment from a lawyer who thought that the opinion was saying that any person would be restricted under Rule 5.6. The opinion makes clear that our rules only apply to lawyers. So Rule 5.6 only applies to lawyers. So the subcommittee, let me back up. The subcommittee met after receiving these 2 comments. And the subcommittee decided that because the opinion makes clear that it's only applying to lawyers and not to the clients or the parties of the litigation, no changes needed to be made to the opinion. The second comment came from the lawyer who actually drafted the confidentiality agreement that's at issue. She wants the opinion to clarify and allow lawyers to agree to a confidentiality clause that restricts a lawyer's ability to disclose the underlying facts and or the identity of the parties if that information is not public and there is an exception built into the confidentiality clause that would make disclosure necessary for the lawyer's right to practice under Rule 5.6. So the subcommittee discussed that. The opinion does not restrict all confidentiality clauses. It just restricts any clause that would restrict a lawyer's ability to use or disclose, publicly available information. The subcommittee, however, did agree to make some minor changes to the language in opinion number 2 to make clear that the confidentiality clause may include non-disclosure of the underlying facts and the identity of the parties, provided that that information is not already publicly available. So we did some wordsmithing, staff did some wordsmithing to clarify the opinion. No substantive changes to the outcome of the opinion was made. So it is our recommendation that with that amendment that you see in your materials, that the proposed opinion be sent to the full council for adoption.
Thank you, Nicole. Evan?
Thank you, Madam Chairman. Once again, this is a great subject. Tara, Kevin, we took what seemed to be simple and we made it very complicated. And then brought it back down again. We started talking about Rule 1.6, 1.9, trying to address these issues brought out by the comments. But we ultimately decided that, like any court decision, we wanted to break the scope of the opinions of what the question was, rather than breaking in sort of extraneous rules to send people down, rabbit holes to chase things. So we decided to excise the language about 1.9 and some other stuff. It's basically unchanged. It does answer the question and it answers it correctly. So again, the subcommittee director preparing this to have complicated, you can put this together. So I'll see if we need another.
I've nothing to add. I thought Nicole did a great job, but I appreciate that you keep it on streamline. Because there were other things that felt like they were signposts, like if you need some more information, you could check this. It's kind of applicable, but it's not directly on point. And we felt like if we open that a little bit. So,
I agree with that, and I think this was I've been on the council a year and a half. This was my first assignment, and this is a perfect example of how this committee works and how the subcommittee works through an issue. And I think come from a great rule. I think Nicole's done a good job.
Awesome. Any of the other full committee members have any questions, comments? Not certainly, I will entertain a motion.
I'll make a motion that we split it to council for that.
Second.
We have a first and a second to submit this opinion to council for approval.
Can I add just to clarify, in case everybody's wondering, well, do we need to publish again? The minor change that was made does not change the analysis. It doesn't change the substance. It's like Nicole said, it was wordsmithing to make sure that the original intent is clear. I don't see it as something that requires publication again, but just in case anybody's wondering, why is it not being published? That's why.
And the subcommittee felt the same way. It's
Yeah.
just a scribble.
Right.
So we have a motion on the floor. Any further questions, comments? Hearing none, all in favor of sending this to council for adoption, say aye.
Aye.
All who oppose? Excellent work. So next, we are going to go with Suzanne and let her give us an overview of this next issue.
This is another work in progress. We received a request from a law, well, actually it was from Lawyers Mutual, to look at a provision that an estate planning law firm was considering including in their fee agreements. The purpose is to try to recoup some of the lawyer's billable hours when a lawyer who drafts estate planning documents is required to participate in litigation related to the estate documents after the death of the estate planning client. The proposed provision would require the client's estate to reimburse the law firm if the lawyer is called to testify or respond to discovery concerning any aspect of the client's estate plan. And the provision states that the lawyer's time would be billed at the lawyer's future hourly rate. The issue is whether this type of provision would be permissible under the rules of professional conduct. A proposed opinion was presented at the July meeting, and that proposed opinion concluded that the provision did not comply with Rule 1.5 of the Rules of Professional Conduct regarding fees, because the provision was too vague and it could lead to clearly excessive fees. After the July meeting, the matter was sent to a subcommittee. The subcommittee met, and the subcommittee members unanimously, everybody agreed that this type of fee provision should be allowed with certain conditions. And I think that there was 4 main reasons that the members of the subcommittee felt they should be allowed. The first is that the future fees are foreseeable due to the nature of the practice. When you are entering into a retainer agreement for estate planning documents, it's foreseeable that there are going to be subsequent proceedings related to that, those documents, and that's foreseeable to the client and to the lawyer. The second reason is that testators have a right to direct payments from their estate funds after their death, and they should be allowed to set out that their funds can be used to defend their estate planning documents. The third reason was that the fear of unpaid fees can act as a deterrent for lawyers who are agreeing to draft wills in certain circumstances, and we don't want lawyers to be afraid to draft wills for, say, elderly people or whatever a specific circumstance might be. And the final reason was the fact that any fee would be subject to approval by someone along the process, either by the executor or the court. So those were the 4 main reasons that everybody agreed that these provisions should be allowed for this type of law practice. So after concluding that the provision should be allowed, the committee started to think about why the proposed provision was not permissible and what would be what could be included in a provision that would pass muster under the rules of professional conduct. So this is still a work in progress, but what the subcommittee agreed to so far was that the opinion approving such provisions should be limited to caveat proceedings. We felt like the subcommittee members felt like this was a particular problem for estate planning lawyers, that it comes up quite frequently in that type of practice, and that we were going to limit it to caveat proceedings. And along those same lines, the subcommittee felt that the provision should specifically exclude payment of fees or expenses to defend the drafting lawyer's negligence or malpractice. And the last thing that we discussed was the lawyer's hourly rate. The proposed provision said that the lawyer's fees would be billed at whatever the hourly rate was at that time. And that bothered a lot of the members, and they thought that the hourly rate should either be the same as when the contract was executed, or that there should at least be a cap on any increase in the lawyer's hourly rate. And that was an hour and a half. We spent a lot of time working on this, and so that's where we stopped, and we're continuing to look at what we think would amount to a provision that would be acceptable under Rule 1.5.
Thank you, Suzanne. And this is Gina.
So I think, thank God, Martin was on our committee, because it's really important to have stakeholders who deal with this stuff in the mix, because I had no idea, as a person who drafts prenuptial agreements, kind of similar, I had no idea that when we draft wills, they are routinely challenged by the bad egg children. You know? Sweet old dad who hired a lawyer 20 years ago to cut out the bad egg children, and now he's dead. But we want to ensure that the will that he thought about 20 years ago and paid for gets enforced as he wanted it to. So I think it's important to think about, who are we trying to protect here? Who is the client? Who is the member of the public who needs protection? Not the bad egg guy, the testator, the dead guy. And so Martin gave us a bunch of things to think about that in the absence of an estate planning lawyer on the committee, we wouldn't have thought about. So this is complicated. Let us have it for a while. We're gonna get there. We're gonna get to yes. It's just gonna be difficult to get to yes. We started at no, we're gonna get to yes, but we need some more time.
Martin, anything you want to add?
We had a very long conversation, we had to re-up our time with Zoom. It was a very good one, though, but I see it in this amount, and in my practice, which is a very, country lawyer type practice, here in the same area. And this unfortunately comes up quite a good bit in the practice, you're not going to deal with it, caveats just come regularly. And it's a real issue, to have to deal with in trying to preserve the testator's intent. But one of the struggles that, and I keep hearing caveat, we did talk one thing, and I don't slide in too much, but normally what will end up happening is someone will file suit also to challenge the powers of attorney that were drafted along with possibly the will. And so while I know we talked about a caveat just on that one, I'd like to take it back with our group and talk more about maybe what if we, the state documents normally include at least the big four: your advance directive, your durable, your healthcare, and your will. And maybe something that we could find some common ground to allow us to extend to that as well. Because of course you have a caveat, which is different than the civil lawsuit challenge. A lot of times they'll put them both at the same time. And the way it normally works is you say the civil action part of your caveat, because if the caveat's not successful, then they could have chosen to get away anyway. And so that's something we need to talk about maybe a little bit more. Yeah, I think we'll get a yes, but not yet.
Guys are doing some heavy lifting. So, anybody else have any questions, comment? Yes.
I agree. This is going to take a lot of time. And one of the concerns I have though with the fee, the lawyer who drafted the will is acting as a witness, not as a lawyer. And to bill it the prevailing hourly rate for that attorney 20 years later might be exorbitant for testifying in deposition, producing documents, responding to subpoenas. So that's one thing that I think needs to be addressed. We want to make sure that this is what the client wants in the fee agreement, not what the lawyer wants, and it's not creating an adherence provision that the testator signs. We can't assume either that the bad egg children is the bad actor. You disprove. I'm as far away from this area of the law as possible. And I'm far away from billing hours. I've worked for the state my whole life, but these are my concerns from the outside looking in, but I'm very grateful that Martin's on the committee to give us that insight.
And we did address that exact issue, whether this large criminal fact witness or was something else going in. So that is something that has not been lost on us as well. And of course, there are other than the bad egg children could be the bad egg sister of the testator who's had the will change now of being her favorite. So there's all kinds of bad eggs that are out there. It's just, but we, yeah.
And I did not realize caveats were that commonplace. I thought they were fluid.
And sometimes unfortunately, we talk about committees, the lawyer's dream, because you have a situation where there may be in a state that's got lots of money, and so we want to make sure we're not generating an incentive for a caveat as well, so that's not a concern. Yes,
Mark Twain said, where there's money, there's mischief.
Yes, Todd.
I've got two questions. One, all correcting from the last meeting, this issue has not been addressed in any other jurisdiction or can we get back to that project?
I have not been able to find it.
Yeah, we haven't seen anything.
The second question is, if I understand this correctly, our rules to apply to one practice area, but not another practice area. For example, this came up in the board contract, and I suspect, I know some boards who can say that we draft contracts all the time and we get litigation all the time in contracts. Do we have situations where our rules already apply to only one practice area and don't permit similar situations in another practice area? I thought our rules apply across the board, equally to everybody. And you have a situation where you have called out a practice area for special treatment.
Right. There,
In now at 1/4, and if we have not, expect the request of something.
We did talk about that, and the rules do apply across the board. The opinion, I think maybe we're going to focus on why a provision, I guess, will be permissible in this type of scenario because of the foreseeability of subsequent litigation. And it might be that it ends up not being limited just to caveat proceedings, but the rules apply across the board, but interpretation and application of the rules might be different. But one of the reasons everybody on the subcommittee, I think, felt so strongly that the provision should be allowed was because when you enter into these types of agreements, it's very foreseeable that there's going to be future litigation, and that's not always the case in every practice area.
I had no dispute with that.
Right.
That's not a factor. I suspect, however, that we could bring some folks in here to say, this is equally foreseeable in our practice.
Right.
And so I just want to consider that as we go forward.
Well, that's an excellent point, Gina.
Yeah.
Yeah.
I draft prenuptial, and I testify sometimes, and sometimes I'm testifying as a fact witness, and I do not get paid to do that. And sometimes I'm testifying as an expert witness, and I probably could get paid to do that. I don't know that I've ever billed anybody, but, I think the rules are clear that I could, if I was testifying as an expert. So I definitely brought that up. The problem, of course, is what we typically try to do in this committee, I believe, and I think Evan just said it, is tackle the singular issue that's before us, because the broad scope is to go all over everywhere and maybe not even get a product. And so we felt like if we limited it to just this thing that happens all the time, but it doesn't happen all the time, the prenuptial agreement, that happens all the time that we will do. And so we were hoping that we could protect the public, deadlines, and give guidance to lawyers and get something accomplished if we limited the scope of the inquiry. If we bring it up to protect people like me and your corporate lawyers who are drafting contracts that get challenged, et cetera, we think it may be impossible to solve the problem because unforeseeability, all the different people that play here. And so I guess the question is, when we're faced with an issue that we can make it skinny and solve, or broaden it and not solve it, what is the task of that?
I don't disagree with you, but I'm thinking it's about something that has not been done before, and that we have to move apply one practice area. And I just want us to be.
Right.
considerate. I could see going forward that we'll start having to parse these rules. Okay, now I'm going to put a rule apply on to this practice area. But right now, across the board, nobody gets special treatment. We'll get away perhaps. Make a little bit of an exception for that, or set a precedent, so that going forward, the next group can come in and say, I need this because we did it 2 years ago for the state planning practice. That's my only concern.
Yeah.
I just had a comment. I think that the difference is, and again, I don't do corporate contracts. I do the kind of contracts that Heidi and Lori and Gina, we can provide attorney's fees provisions in those agreements, and we do a lot of times. And I'm sure in these corporate contracts, you can do the same thing. You can say, okay, if you breach it or you challenge it and you lose, you got to pay attorney's fees, you got to do, and that's different from, I think that's a distinction, the difference. But again, I don't do your
I just want us to be concerned about the rules that now we apply to one practice area without another. Whereas at this moment, these are.
No, excellent points, and they've already said they've got a lot of work ahead of them, but I think Brian's got another.
Yeah, no, I was just gonna say, the ripple effect of these opinions can be very real and significant. And we have, to Jack's point earlier, of folks that look at one aspect of an opinion and they try to exploit it. That is the sort of thing that I think this opinion, why it was originally drafted as a no, because we were looking at it very broadly, understanding the really difficult spot that the state lawyers are put in, and especially one that's so predictable, especially now. And so I think that's where I understand. I did not participate in the meeting, but I understand that the conversation is kind of considering the full ripple effect of what's going on, and to see, is there going to be some sort of, in light of this conversation, is there going to be a thought of, well, what are the other solutions that are available? Let's vet every possibility. But I do think we have opinions that have been limited in scope to a particular aspect, maybe an area of law in this particular scenario. But we all know that if somebody wants to argue this is applicable to my situation, they're going to do it. And then it becomes a grievance matter, potentially a disciplinary hearing commission matter. And I have heard arguments to that effect in DHC proceedings. So it does have, it will have an impact, however it comes out. But I think that's where it's kind of a threading the needle sort of situation to see exactly, can it be thread to begin with? And if so, what's the effect on other practices?
And toward that end, I think it's important that we let everybody know, it's not gonna be solved next time you see
Right.
y'all.
Yeah. I'm hearing Gina say that we will, we'll likely have this opinion whenever it gets into a form where it can be published. It'll be published during Todd Brown's presidency.
And he's not here, so that's perfect.
Another.
So one thing I just wanted to say, because we've got you here, Warren, is, so when I was in private practice, I worked with Lawyers Mutual Insurers. So Lawyers Mutual would hire me to represent their insurers when they receive subpoenas and caveats. And so I represented lots of folks in this specific type of situation, but then I've also represented Lawyers Mutual Insurers and all other types of cases. It really does seem like an insurer like Lawyers Mutual has some really good information about, is it true that there are more claims around these? And sort of what.
More schemas, right?
Mhm.
Yeah.
And my feeling is yes, but that's just, that was my practice area, so of course that's. But it could be helpful for us to the extent that type of information is available from Lawyers Mutual, and I'm sure the most folks in the state, to get a sense of how significant the issue is. Because I do think it would give us more than just sort of what we feel like is there. But it is a significant issue. And and what we talked about in the committee was certainly distinguishing in the opinion about when you can charge the fee to when you are called as fact witness, and when you are being sued, because sometimes you're being sued.
And of course, you would not be able to recover your fees then. Just want to make sure that's completely clear. I will tell you, the issue sometimes comes that you are subpoenaed, you are called as a fact witness, and then you are sued. Because of your testimony. And so that's something you need to be aware of.
Tom?
You know, I think I could see a criminal lawyer picking up on where a criminal lawyer put a provision, want to put a provision in his fee agreement that there's a claim for ineffective assistance of counsel. That these fees are going to be covered or he's prevented. That's gonna, I mean, I can tell you, ineffective assistance of counsel claims are as prevalent, if not more prevalent than those kinds.
Me and my brother, actually, that's the number one.
We'll be careful before we open that door.
Yeah.
Yeah, we're not gonna open that. We know it's
Gina,
not.
2024.
Yes.
And I just want to make sure people do caveats, because typically the fact issue is either the person did not have capacity to sign the will and the lawyer should have known it. So that's part of, if you don't already have that information, you have to call them as a fact witness first, or you have to depose them first. Or that there was someone, unduly influencing that person to execute the will, and then the lawyer has some information about that. But again, if the lawyer was aware of some type of undue influence, again, that can subject the lawyer to liability. So it's just not as clean as we would like it to be. I would say, I do think it would be great if lawyers could be compensated for this, because typically a lot of them have like a $5,000 deductible on their insurance policies, and they were paying off this out of pocket. So it really is a significant expense for lawyers to do that work.
Sounds like there's all kinds of things. And it sounds like I'm gonna hear a motion for you to keep this until what? 2024? So I have a first and a second to keep, keep this in subcommittee. Any further questions, comments? All in favor, say aye.
Aye.
All opposed? Right, Gina, good luck. So let's go to the inquiry of Reese and Nicole.
Yes. So this is a proposed opinion about installation of a third-party self-service kiosk in a lawyer's office and inclusion of that lawyer in third-party advertising efforts. In the inquiry, a company wants to rent space from a lawyer in a lawyer's office and leave a kiosk for ignition lock services, so that the lawyer's clients who are ordered by the court to implement an ignition lock on their car can sign up using the kiosk right there in their lawyer's office. The company will pay rent to the lawyer, they will support the kiosk, and will include the lawyer in advertisements as a provider. The company will also pay the lawyer a referral fee for each client of the lawyer that signs up for the ignition lock service at the kiosk. The proposed opinion allows the lawyer to have a kiosk in their office based on Rule 5.7 law-related services. The opinion also cites Rule 1.7 on personal conflicts of interest and Rule 7.4 on intermediary organizations with regard to the advertising. After the April meeting, this opinion was sent to subcommittee. The subcommittee met. The first thing that they were concerned about is that because the lawyer is getting a referral fee for any client that uses the kiosk, they're essentially getting free advertising, that it would create a personal conflict of interest for the lawyer if there were problems with the kiosk on the back end. So for example, if the client violates the conditions of the key lock, or the ignition lock service provides a false positive to DMV. These problems on the back end will prevent the lawyer from representing a client against the company, as what the subcommittee was concerned about. Next, the subcommittee discussed whether or not the allowing clients to have access to this kiosk in their office is really a law-related service being provided by the lawyer. So Rule 5.7b provides and defines law-related service as denotes services that might reasonably be performed in conjunction with and in substance are related to the provision of legal services and that are not prohibited as unauthorized practice of law when provided by a non-lawyer. So the committee was concerned was that the lawyer's not providing any kind of service with regard to the ignition lock. The ignition lock kiosk is just in their office, so is it really a law-related service? The subcommittee ultimately decided that it is not a law-related service, and the opinion should delete that, the language regarding that. Instead, the opinion should focus on the personal conflict of interest caused by under Rule 1.7 due to the lawyer's financial interest and problems with the ignition lock on the back end. The subcommittee then discussed the referral fee that the lawyer gets for referring clients to use the kiosk service. And unanimously, the subcommittee did not like the idea of the lawyer getting a referral fee. However, there's nothing in the rules of professional conduct that prevents a lawyer from accepting a referral fee under these circumstances, because it is not a fee for recommending the lawyer services. So the subcommittee decided they will table that until their next subcommittee meeting. So again, this is another one, like Suzanne's, a work in progress. We still got work to do. So the subcommittee decided that they wanted to keep this in subcommittee. They want me to change the focus of the opinion to personal conflicts of interest created by the personal interest and do an analysis under Rule 1.7 and delete the reference to 5.7. The opinion also has references Rule 7.4 or intermediary organizations with regard to the lawyer advertising, and the subcommittee felt that that part of the opinion was fine and no changes needed to be made, but we just need to focus on the personal conflict of interest.
Thank you, Nicole. Kevin?
But as you all may remember, the last meeting we had, there were a host of concerns that were voiced about the conflicts that can arise. So that's ultimately will be moving to keep it in subcommittee. I got stuck in court for the meeting, so I wasn't chaired. So I would defer to him if there's further pieces there, but I think that's the intent, is to continue to go down the road in the conflict.
Evan?
Well, I just got to say, I watched a lawyer argue a motion to suppress a search warrant, and his statement to the judge was, "Judge, this warrant is just covered with taints." And so that's what is me. You know, everything about this whole situation rubs my foot the wrong way. Everything. From a referral fee to the kiosk, advertisement, you know, to the conflict of interest. There is nothing about this opinion that I like. So,
Don't hold back.
so, you know, and I know, and Nicole was great, you know, she kept us focused on the rules and what was permissive as opposed to what's not. And I think Brian said, the fact that there's a yuck factor to this, that's just your word. It should not prevent us from, you know, keeping this on the path of, you know, compliance with it. But, oh my God, this is it's got taints all over it. So, anyway, it's got to go back to something. We'll deal with the taints. That's why I'm not going to get it together.
What, any of the other subcommittee members have any comments, and can you not use the word?
I will say that Evan held back during the subcommittee. Because I didn't know that he felt that strongly about it. I asked to serve on the subcommittee because at our last meeting, people were talking about the yuck factor, the ick factor. My thought was, if you have ever represented a poor person in a rural county, this is a tremendous access to a service that they need. These people are in the situation because they don't have a driver's license. So to be able to drive an hour or two to get to Emerald, it is a burden. So I get it, but I do it? No, it's kind of icky. But if there's a lawyer out there that's willing to provide this service, especially to non-English speaking clients, to people from marginalized communities, this can be a huge access to a service that the public needs. So I asked to join the subcommittee because I didn't want us to make a quick decision not to do this because it doesn't feel right. And if you look at Ryan and Nicole's work, there's no reason that a lawyer can't do this. So anyway, just want to put that out there, but, yeah, you had a good meeting. I bet very well.
Chair can't vote.
This would be neutral.
I didn't vote next.
Any of the other subcommittee members' comments? If not, Jack. would you have a-
I'm in Evans camp. It's causing me a lot of problems. We might be in a race with Venus. Who finishes first or who finishes last?
Well,
We got
race
like
to the bottom, we're gonna end up on the bottom.
Anybody else? Otherwise, I'll, Jack.
Yeah, no, I just forgetting whether or not, it's a conflict issue or not a conflict issue, and I understand your point about the access. But do we have a mechanism, like some kind of rule of professional conduct that just allows us to promote the profession in a classy way?
Yeah, well, it's on the executive committee agendas, or this afternoon. It's rule 9.1, don't be an idiot. I'm kidding. That's not real. No, it's, and I think this is, to me, this is where we start getting into the weeds of ethics. Because the preamble is where we have all of our different aspects. Where we're talking about, what a lawyer needs to aspire to. And whereas the rules set the floor, right? You have to at least do this. So yeah, I think that's the sort of thing that we struggle with this and in other matters. Remember just being in the grievance process. Those of you that serve on the grievance committee, you have seen situations where you're like, gosh, this just smells to high heaven. But I don't know that a rule violation occurred. And then there's ways to address it there, with like a letter of caution. You send it to the Chief Justice Commission on professionalism, things of that nature. But so all that's to say, I don't know that there's that particular mechanism. But in these opinions, this might be one of those, just because you can doesn't mean you should. And I don't think the committee is prohibited from articulating that perspective. Okay.
You would get this room that.
And I would add, by not only not prohibited from saying that, but also not prohibited from putting pretty strict limits on it.
Yes,
To
yes.
decrease.
Yeah,
Said.
So lots of things to balance. So it sounds like the motion is going to be to keep it in sub.
So.
A second? All in favor, say aye. Any who oppose? All right, remain in sub. So before we get into artificial intelligence, we're going to take about a 10-minute break. It is 10:15, so we'll come back about 10:25, go get some coffee, stretch. We're going to need all that brain power for AI. Good. two inquiries that we're going to talk about. And the first is the use of artificial intelligence. Brian?
Well. All right, so artificial intelligence, you have in your materials a memo that introduces this topic as well as a number of other things I'll go through briefly. But the gist is this: we have, as you can imagine, received a number of comments, inquiries, nothing terribly official, and I feel like they're informal inquiries of folks simply saying, what is the deal with artificial intelligence and how does this impact the practice of law? It's clear that, and I put this in the memo, I put it in this article that I've drafted. Artificial intelligence has made some pretty substantial jumps over the past few years, and particularly this year with the release. I've detailed the release of this ChatGPT version 4 that apparently has passed the uniform bar exam. So it's something that is, I see, not going away. I know there's discussions on what sort of regulations will the federal government put on the use of artificial intelligence, the development of artificial intelligence. You see in what we've kind of started with is I've drafted an article that's supposed to be published in the journal this quarter, unless there's any sort of objection of that's horrible. But try to outline just what are we talking about and how does it actually integrate with the practice of law. You'll see in just kind of reference the article because I thought it was a kind of a funny way to introduce this whole thing. I asked ChatGPT, what are the ethical considerations of a lawyer using artificial intelligence in the law practice? And for those of you that have read the article, you know what I'm getting at. If you haven't, you'll be surprised to find out that it provided a very decent answer. And I drafted the article in a way that, you can read through it and you might think that I am actually writing that, but I did not write that. And point that out that this was ChatGPT's answer to the ethical consideration. It hits on lawyer competence, supervision, still cringing that ChatGPT thinks it should be supervised and it equates itself with a human. But nevertheless, confidentiality, the communication that you have to have with lawyers, the diligence and checking behind the work, potential unauthorized practice issues, billing issues, bias and fairness. I mean, it's a thorough answer. Granted, it doesn't get into the weeds. It doesn't really explore just how do billing issues come up and what should a lawyer consider when they are crafting a billing structure that is based upon their use of artificial intelligence to complete the work product for a client. So the bottom line is that I think we as a committee are facing something, as are all state bars, facing something in artificial intelligence that is new. It's not going away. If anything, from what I understand, the artificial intelligence is only getting better because the longer it exists, the more it learns from itself and things of that nature. But of course, there also is, there's plenty of demonstrated problems with it, and most notably in the article, I pointed out how you may have seen news articles, a lawyer has actually used ChatGPT to draft their brief, and the program created cases, just made cases up and said, this is the citation, here's my citation. It might have been even a citation to a real case, but the case didn't say what the program said it said. So the article that I've drafted is meant to be kind of an introduction to those that don't know we've all heard about it, but we don't know exactly what we're doing or what's going on. This is supposed to provide an introduction, kind of get us on the same page and state what I have told folks before in my conversations, that essentially treat artificial intelligence like any other software. I mean, if you're going to use it, you better know what you're doing. If you're going to rely on it, you better go back and check behind it. You have all the same duties because when you submit that brief, it's under your name and not under ChatGPT. And that there's nothing in the rules that prohibits a lawyer from using artificial intelligence or other machine learning processes. But again, it's going to be your ultimate responsibility. And so, especially in light of the different flaws that you've seen, it's that much more important to be vigilant, really. So we start with the article, but the question really before the committee is that enough? Do you all want to study this and potentially issue an ethics opinion? No jurisdiction has issued an ethics opinion on artificial intelligence. I think we tackled this before in a different way. In 2021, we had an inquiry come in about a lawyer's use of machine learning processes, which is kind of it's another way of saying artificial intelligence, but maybe not as sophisticated. And we issued an ethics advisory opinion, one of those letters. That is something that we keep on file, but it's not published. I'll tell you, we have sent out that ethics advisory opinion because it's public, it just wasn't published. But we've sent that out in response to some people who have called in and sent us the emails asking about what exactly are the parameters for my use of these developing capabilities. We decided back then to issue only the ethics advisory opinion as opposed to a formal ethics opinion because it felt like this thing is constantly evolving. We're not ready. We're not in a place where we can really put our hands around this idea of artificial intelligence. And so we need to wait. I think we're putting it before the committee now because it seems that this thing continues to evolve. I think one idea is that lawyers may benefit from guidance that's offered this high level that basically is reflected in the article. But the reality is that if we wait until this thing settles down, we will never issue an opinion. So it's a question of whether we think an opinion would be helpful to the profession. And if so, what does it say?
So Wade, before we go, we have Warren, Craig and Tara. Y'all's homework was to be ready to comment. So Warren.
Can I pause before you even get into that? If anybody has not met our interns for the state bar, they just walked in from the grievance committee meeting and they're not allowed us to tell us anything about what happened over there. You all want to stand up and introduce yourselves?
Good morning, everyone. My name is Brenda Pearson, I'm with Terry, and I'm rising to Real at Wake Forest. Hi, everyone. My name is Marie Anderson. I'm rising to Real at Central, and I am from 20 minutes out of Charlotte.
Welcome.
Thank you.
Warren.
I want to thank Brian again for sticking me on another. And my thought is that I definitely think we should go to subcommittee, and I think we should get ahead of it. Whether we have an opinion or not, we can't decide that here and today. I think we need to get into it and the weeds a bit. If not, things are going to start flying at us on this topic. They're going to come at us fast and furious, and we're going to be in catch-up mode and never really be able to catch up. I think I've seen several. I've seen a couple of presentations about AI. One by a Duke professor, Westlaw and others, and Lexis are both going to have a layer on top of their stuff right now that's going to have AI that they can sort of generative stuff that they can do, where it's going to probably solve this problem that these lawyers had who just use ChatGPT. They're going to solve that. So the last comment, there's all kinds of stuff there's already folks that are taking billions of dollars into platforms that are going to be on top of this ChatGPT that is going to be marketed to us, or you name it. It's just amazing what is going to be out there and what can be done. And we're going to be coming back to this on this film. We're going to be coming back to this on issues of competence. I can't imagine the number of things that are going to come to us as this develops. And I think if we don't, I think it's very wise to go ahead and publish your article, obviously. But get a committee together, start deciding whether maybe have some sort of task force so that when things start coming in, I just think it's today we're going to get a bunch of them over there. Next year, this time, the stuff that's out there, it's making itself smarter as we speak, because it's listening to me on streaming video Speeding that in there. It's gonna make it- making itself smart.
I don't know if it's making itself smart.
This time next year, it's gonna be doing a lot more than we. Reading about some of these articles about that, so.
Go to Craig.
Well, I thought the article was very entertaining. Thank you for putting that together. I think your idea of letting it marinate a little bit, but also perhaps signing a group to work on it is well founded. I think this is going to be a game changer, there's no question. The pace at which it develops and integrates itself into the practice of law is only going to accelerate. There is a retired Superior Court judge in Charlotte, Chase Saunders, who's put together a group of people from firms, including IT people, practicing lawyers, general counsel of our firm is part of it. I don't know if you interacted with him or
I'm
not.
not.
And I would suggest to him maybe that he reach out to you
Mhm.
so that you get the benefit of that. But I think that the poll stars that are identified in the article, those aren't going to change. I think those are going to be constants. It's something I think is going to be important to get out to our membership. And I would suggest that we do that sooner rather than later.
Excellent. Tara?
I agree as much as it can be said. I think it has to go to subcommittee, and it's gonna be a lot of discussion, but I spoke with, a law student internally in our area. And, she brought up some interesting points about how law schools are handling it, and maybe our interns would have some, have something to add to that, but I think midway through, their fall semester, at least at Campbell, they actually had everyone come back in and swear to new ethics and citizenship guidelines that says I will not use any AI software for my essays or whatever, as opposed to the stock one that they sign every year. And from, that's just, I guess, a small example, from August to October, it changed that quickly. And I really like the article. I think we should go ahead and publish that. But I am curious to where this is going to go, but I would learn about it.
Wade.
It's two observations. One, could we have a luncheon learn about this? I haven't tried it yet. I think that would be very helpful to let folks get a taste of what it's really like. Number two, when you're thinking about this task force, put young people
No, excellent.
on.
Judge?
I was actually gonna suggest, what several others have already stated, because too, at North Carolina Central School of Law, they have also addressed this issue. And I think that it's necessary for us to look at it. I think it's good for it to go to subcommittee, but I would encourage you all to seek some members from the law schools, maybe the law librarians, research folks, as well as the IT folks. And hopefully that would include some young people too, because they do have a very different viewpoint. And I was thinking, I mean, we kind of were joking about the use of artificial intelligence in the law practice when we were talking about it as far as research. But as you all have seen, especially on social media, everybody's using it for like their headshots and everything too. So it's not just the research. I mean, because you could have somebody in the law firm use the AI to spruce up their picture, and then the person comes in and they look like a totally different person than what they, I mean, so that would include the use of it in the law, you know what I mean? So I think it's even more than what we're thinking about. I know it's, I mean, I'm joking about it, but it really goes beyond just the research piece of it.
Evan?
Thank you, Madam Chairman. I had a conversation with Mark on recast 3 or 4 years ago when he was chair, and I asked him about this. I said, you know, we womble call out of they call bond something now. Are you guys really starting to dig into AI? He said, yes, very much so. A lot of resources going into this was 4 years ago, and maybe 5. And so we got Todd, we got Craig. I don't see anybody else here that's in mega firms, but, you know, that sort of have this kind of capability. But, you this is something that I'm sure the big firms have been dealing with for years now and trying to assimilate that in a way that works ethically and economically. It's been around for a while, and it's going to keep being around. And so it's going to take, this might be some kind of continuing substitute. So, it will more.
Ashley.
I just wanted to share with the group that, so Legal Aid of North Carolina has just launched an innovation lab. And the purpose around that is obviously, as you guys and information to our clients. And we are definitely, exploring AI and all of that. And we have an advisory committee to, for this point, there are a lot of great people at some law schools and around at State and Duke that are really knowledgeable about this, but there's also a program called Harvey. You guys heard of this? That one of the law firms has developed, one of the large law firms, not in North Carolina, but somewhere else in the United States, has developed to do their own internal AI. So they use it to like run their internal operations. But I agree. I think we need education on this. And I think doing a CLE would be great. Or whatever, lunch and learn for everybody to kind of get them up to speed would be really good because there's so much.
Yeah.
And I think this is going to be a huge part of what we're talking about over the next couple of years. So I'm glad for us to, I'm glad to be on this meeting. You guys.
For something real quick. I know there's been kind of a question of lunch and learn, a CLE, all that. I'll tell you, I'm presenting a CLE in October with Jeff Kelly. Jeff Kelly is with Nelson Mullins, and he's been my go-to for just what am I looking at? And he's very involved in the Bar Association and their different committees that are dealing with this. But we're going to be presenting one on the just kind of what are we talking about when we're talking about AI, but also the ethical considerations there. So that's we have the Bar Association in the early part of October. It may serve as a foundation to offer that to just the full council. I'll have to talk with Jeff about that, but I think the educational component is crucial here. And that's where, to your point, Evan, this has been around for a while. We have an old ethics advisory opinion that Warren has served on. That committee and the fact that we're putting it back on the agenda, I felt compelled, especially after talking with Catherine, that we needed to reevaluate whether it was time to have something a bit more official because, like to Craig's point, the principles are going to remain the same. We may not be able to address specific programs. That's always been a problem with all of our opinions because those programs change and suddenly the opinion is obsolete. But if we can articulate and give some guidance to lawyers that will be constant, despite the evolving nature, that may be the best way forward.
Bill?
I would just encourage everybody, question is, what isn't what is AI? The question is, what isn't AI? And because it can level up a very small practitioner to level up a mega firm, but it's not just writing a brief. It's not just writing code. You can auto-generate responses, emails, texts. You can do financial calculations. You can have it look at pictures and describe the one between out. They had a picture of a roast beef sandwich with a piece of bread and potatoes out. And so please write an article on the nutritional aspects of the sandwich, estimate calories, and look at the picture and do it. And it's something that you can't ignore, and what's even more frightening, they've actually modeled the functionality of these, particularly BART, who's only by Google, who use the internet, we're still using AskJeeves. But the point of the matter is, it's going to, someone mentioned it before, that it's recorded right now and learning. AI is learning at such a fast rate that it's going to outpace anything you can buffer it. And I showed like right at like 2 minutes. Found this it should be a standing committee because it could address what happens when the pro se litigant files a complaint or tell you to face all that's inaccurate. Or the committee will use this as an auto response to your phone calls or your inquiries to clients. It encompasses every aspect of everything you do in your professional life.
Ellen,
I agree with Bill, and I'm really glad we're talking about this. I think it's a serious issue, and I think it's easy for us to laugh at it and say we don't know, but I think we all need to try to know. And I think the educational component is really threefold. It's us, and then it's gonna be the lawyers, and then to the extent that our job is to protect the public, it's gonna be to the public. And there's sort of an order of operations there. Our students are using it, and I personally think that's good. We have not done a similar thing with our honor code globally. What we have done at Wake is given professors autonomy, and I and some others have actually given aspects of our exam that say, on this part, you may use ChatGPT, or you may, and then critique it. And we do that in class, right? And so we are teaching our students how to use it. These guys are gonna know how to use it. And they're soon gonna be sitting where we are. And so I think we have a duty to make it a standing committee. Judges are overwhelmed. I've talked to a lot of judges who don't know how to deal with this. And I think that it was an educational, not that we can educate everybody, but I also wanna and I'm scared of it too, but I want us to also think of it when we think about it as when might we want to, and arguably when might we be required to? When might we be helping the public by using it? There was a Canadian case a few years ago where a judge disgorged fees because a lawyer did not use research software to more efficiently do research, right? And so let's say the fees went from 10,000 to 2,000 or something. But the point was the judge was saying, look, you have a duty to know about this as part of your duty of competence and to use it in a way that helps your client. I know we're a long way from that, but I just don't want us to always think about it as when are we going to prohibit its use, because I think there may be benefits.
Gina?
I was gonna say exactly what she just said. To Wade's point, I think we need to put old people on the committee too. Jay and I, what he does on his phone every day, and Jay's so upset, he's gonna be staring at this screen about it for a week. So I think we have an obligation to understand it and address it, so we need greater people.
You guys call yourself old?
Nancy?
I was gonna say, kind of commenting on the other suggestions that were made, I think it's easy to have the knee-jerk reaction and consider the negative use of this, the things that scare us, but there could be some really positive uses. And kind of taking off what Ashley said, I could see it very much being an access to justice issue. I mean, imagine a indigent pro se party that can put certain information in, and where we have maybe a form in our courthouse to assist in the drafting of a simple custody complaint or something, something that's a lot better quality and covers the areas. So I think we also have to resist just having the negative knee-jerk reaction to it, but look at it from a broader standpoint and how it could potentially assist the legal services, providing legal services to people who don't otherwise.
Right.
And I'll give an example of that just for the group. So there's a chat bot that's already been developed. It's out at like all the technology conferences, and I can't remember what it's called, LawDroid maybe. That so at Legal Aid, we have tons of material on our website, all kinds of videos, tons of pro se material that we've been developing for 25 years. And it's hard to sort through when I've received a summons for summary judgment, what do I do, right? So you gotta sort through all that. LawDroid will allow you to type that question into the LawDroid. It's like a little chat box at the bottom of the screen. I've received a summons for summary judgment, what do I do? And LawDroid will scrape just your website. So it doesn't go outside and get unreliable data. It will scrape your website and provide an answer to the person. So that's the kind of technology. I don't know if you guys have heard of that. That's already out there and being used, just like what Nancy's saying, in a really effective way that appears to be working well.
Right, Bill?
You can tell it now if you straight from site and write new HTML code in order to make the site more easy to use and functional for that user. It will write the code for you. So, and suggest pictures.
Well, I don't know. There's a question that we cannot open Pandora's box at this point.
Yeah.
So
It's
I
already
think
been
we need whoever wants to throw out the hat and make the motion to create a subcommittee.
I'll make a motion.
Do we have a second? I would say further questions, comments, but we're gonna have, I mean, this is gonna go on. We don't obviously have the ability to establish a standing committee, but certainly it's going to be something that is going to change the face of what we do. And might as well be ahead of it. So all in favor of making this, sending this issue to subcommittee, say aye.
Aye. Any
who oppose? And so I will certainly talk to Matt, because when I think of artificial intelligence, Matt.
He's really leaving.
All right, let's get to inquiry of Bradley.
All right, so inquiry of Bradley is also new inquiry on your addendum. This is a, I guess, an extension of an opinion that we had, that we published, adopted about over 10 years ago. The original opinion, 2010 FEO 14, is in your materials, but that one dealt with this issue of keyword advertising. The scenario was lawyer A is competing with lawyer B, and lawyer A is starting a keyword advertising campaign. This is in the 2010 opinion, but lawyer A basically wants to increase visibility on the website, so they purchase lawyer B's name as a keyword, i.e. when somebody is searching on Google for lawyer B, they're actually going to see lawyer A's website pop up as a sponsored link and advertisement. I know it's gone through a number of different iterations, but the lawyer A's law website is displayed, right at the top of the search results. The ethics committee found in that opinion that would be dishonest to intentionally purchase another lawyer's name for keyword advertising. Well, we fast forward now to 2023, and we had an inquiry come in about law firm trade names. And the opinion that we drafted, the inquiry was specifically about a particular type of trade name, which I'll get to, but we drafted the opinion in a way that basically addresses the first question. All right, can I purchase another law firm trade name that's specific and identifiable to that particular law firm? The opinion gives the example of Strike 3 divorce lawyers in Durham, North Carolina. And the answer to that question in the opinion is no, you can't do that, because that's the equivalent of purchasing another lawyer's name for keyword advertising purposes. You're trading on that person's name, their specific unique identity. And that creating that connection is dishonest. It's neither neither fair or straightforward. But then the inquiry that was submitted to us really concerned what can a lawyer do, or basically the lawyer wants to purchase a keyword phrase that is a generic description of services that also happens to be a law firm trade name, like Durham divorce lawyers, Raleigh divorce lawyers, Triangle divorce lawyers, Charlotte family lawyers, registered with the Secretary of State as a trade name, but it's also a common search term that the public would rely upon. And the opinion says that essentially the protection that's offered, the prohibition that lawyers cannot purchase that unique identity of the lawyer, or now the law firm trade name that's unique to that firm, that does not extend when the law firm trade name is essentially a common search term. Why is it different? Because the public would essentially be deprived of their ability to use common search terms to look for services that you don't know that a consumer is actually looking for Raleigh divorce lawyers when they search Raleigh divorce lawyers. They're not looking for that firm. They may be looking broadly. And so to essentially tell lawyers you cannot select a common search term as a keyword for your keyword advertising campaign really is not even so much that it's not even looking at the effect on the lawyer that's trying to purchase the name, or the law firm whose name is being purchased. It's really a focus on the public. You're depriving the public of the ability to fully access all the potential legal services at their fingertips. So the opinion, again, the draft opinion is in your materials. And we broke it down in that regard to try to kind of extend the question that was started in 2010 FEO 14. But certainly would be interested to hear the committee's feedback.
Davis?
Sure. So I did reach out to Brian right afterwards and told him that I was happy to work on this subcommittee. I will give a full disclaimer that despite being born in the early 80s, my wife does call me a boomer. You know, in terms of technology, so stuff like artificial intelligence makes my head explode. But I did geek out a little bit on paid search advertising, which is what my wife does for a living. So I asked her all about this stuff. And, yeah, I think we should get some outside input from somebody in that line of work, because that's not exactly what we do. Some of her feedback was that, one, this may be impossible to enforce because of the way Google does stuff. I don't know why, but she said it would be very, very difficult to enforce. She gave some examples of, so we do personal injury laws. It's like, well, keywords that she does our digital advertising. So she says some of our keywords that we purchase are personal injury lawyer. Now, Google associates that certain law firms with those keywords, and so they may search personal injury lawyer, or no, they may search a certain law firm, and our ads make it. And we're not buying that law firm's keywords.
Right.
That's kind of a side note, I guess, that it's just something we can dig into. But I think that we should go into subcommittee with this to see where it goes. I think the opinion as written, I have some issues with the vagueness of it about, how we're going to get into, trade names versus, people these days, like we're a truck injury law firm or, whatever it is, they're creating their names to be more, slogans than actual like names.
Right.
That's all my feedback is. And I didn't know if when the 2010 or 2012 opinion came out, was there any outside input from specialists on that? I don't know. Anybody?
I wasn't there. So.
Good information. Bill?
Rogers. William Rogers.
I'm sorry.
No, I'm assuming that you're going to echo what David said. That this should carry to some. Anyone else have any comments about this particular issue? I think, does anyone have a motion to send it to subcommittee? Move, or a second? Second. Have a first and a second. Any further discussion about this inquiry? If not, all in favor of sending this inquiry to subcommittee, say aye.
Aye.
Any who opposed? Send it to sub.
That's it.
All right. Well, thank you all. It's been great. Everyone go get on ChatGPT. You're all doing it right now. I can tell by their faces. Poor Jay is not going to take his face out of that computer. So yes, please go recreate.